Hello, everyone, and welcome to One Civil Law. And for today's story, we are looking at a case the U.S. Supreme Court just granted cert on, but the case is so stupid, it makes you wonder who's serving on the 11th Circuit Court of Appeals. So I'm not surprised the U.S. Supreme Court granted review, but I am surprised the 11th Circuit is idiots because I don't understand how they can reach a decision this incredibly dumb. So we turn to the case of Martin versus United States out of the 11th Circuit Court of Appeals, decided April of 2024. The U.S. Supreme Court just decided to grant review on this case. So the U.S. Supreme Court will have to decide, did the 11th Circuit make a mistake? Could go either way. Who knows? So what happened in this case? Well, the facts of the case are pretty simple in their basics. So we'll just read the introduction here. Plaintiff Martin, their minor child, and Hillary Toy Klatt appealed the dismissal of their action for violation of the Fourth Amendment. We got some people who think their Fourth Amendment rights were violated. In October of 2017, agents of the FBI executed a no-knock search warrant at Appellee's at the house, which was not the address identified in the warrant. So the FBI can't read. The FBI can't read. The 11th Circuit isn't necessarily the only one that's stupid, but they might be maximum stupid. So the 11th Circuit has a warrant for a house, and they can't read the address, and so they're dumb. The target address was reportedly the home of Joseph Riley, a violent gang member, was located approximately a block away from their house and shared similar features with the house, which makes sense probably because, like many houses in a subdivision, they look similar. But you know what would have been really helpful? To check the address. Okay. They sued under Bivens, which is an action that sort of kind of is like 1983. 42 USC 1983, as I'm sure many of you are aware, is an action that allows you to sue a state-level official for violation of your civil rights. You can't sue the federal government under 1983, but they do have something called Bivens. Bivens is much more narrow than 1983, which is saying a lot because I'm sure you guys are well aware of how constrained 1983 can be, but Bivens is even more constrained than that. But they sued under Bivens and under the Federal Tort Claim Act, which is a law that basically says the federal government got to pay yo, alleging the FBI violated their Fourth Amendment rights and were liable under Georgia law. Okay, fine. So the fact pattern is pretty simple. The FBI went to the wrong house, damages occurred, they want to sue for the damages, right? That makes sense. Okay. So the court does a whole analysis and they do a qualified analysis. They do a qualified immunity analysis, as you kind of expect. And they say there's qualified immunity, which, you know, not particularly surprising because we know how expansive qualified immunity can be. But then they write a stupid. And here we turn to the stupid. The Court of Appeals writes, the district court correctly ruled the Supremacy Clause bars application of the Federal Tort Claim Act. The Supremacy Clause bars application of the Federal Tort Claim Act. What? All the lawyers in the room are like, what are you talking about? So the Supremacy Clause, as I'm sure many of you know, says the federal constitution and the federal statutes are the supreme law of the land, right? So if you have a conflict between federal law and state law, the federal law will win, assuming, of course, the federal government is acting within its lane. So assuming the federal government is acting pursuant to federal authority, and so there's a thing that they're doing that they can do. This is a power they actually have. So if they don't have the power, then, you know, fine. But if they do have the power and the state's like, we don't want you to do that, federal government wins. Federal government wins. Okay. All right. It's not that hard. Okay. Federal law is supreme to state law. Cool. Apparently also federal law is now supreme to itself because the federal supremacy law that says federal law is supreme says the federal law is invalid. The Federal Tort Claim Act a federal law is invalid because it has to bend to the supremacy of federal law, such as, for example, the Federal Tort Claim Act, which is a federal law. Okay. I don't know how we're gonna read this stupid. This okay. I don't know. That doesn't make any sense. Under the Federal Tort Claim Act, a plaintiff may bring certain state law torts against the United States. So we'd like to sue under state law. We'd like to sue the U.S. federal government under state law. Can you do that? Well, the federal government says you can. The federal government passed a law saying explicitly that you can. Right? I mean, if they hadn't passed that law, then, probably not so much, because you're trying to sue the federal government under state law. That doesn't really make sense. But the federal government said, we are willing to be sued under state law. Okay. The FTCA waives sovereign immunity for wrongful or negligent acts or omissions of its employees if a private person under the same circumstances would be liable under the law of the state. Cool. So the federal government says, we have this thing of like sovereign immunity because separate sovereign. We can't be sued under a state law because we're a sovereign. But the federal government says, you know what? We can be sued. It's cool. You can sue us. And, you can't sue us because of the Supremacy Clause, but it's okay. You can sue us. You can sue us. We are willing to be sued. Okay. So the federal government says we're willing to be sued. Cool. All right. However, the FTCA exempts from liability state tort claims arising from governmental official performance of duties or functions that involve discretion. The discretionary function exemption to FTCA waiver of sovereign immunity exists to prevent judicial second guessing of administrative decisions. Okay. So if we could go this way or we could go this way, if we have multiple different options, then you can't sue us. You can't sue us because we picked the wrong choice. Did the FBI have a decision to make in this situation? No, they didn't. They didn't have a decision to make. They had a warrant that says, go to this address, do the go to this place and do the law enforcement thing. The FBI has no discretion. About what to do here. I suppose they can decide not to do it, but if they're going to do anything, they can only do this thing. That's the whole point of the warrant. The warrant is the permission slip. So the warrant says, go to this place, do these things. Don't go to other exciting places. Don't do other exciting things. This place, these things. Did the FBI have a choice to make? Nope. They certainly didn't. So this clause doesn't seem to apply. Great, moving on. To determine whether the discretionary function exemption applies in given circumstances, courts apply two-factor test. They examine whether the alleged act was discretionary in nature, meaning the act involved an element of judgment or choice. No. And whether the act represented the kind of contact the discretionary function exemption was designed to shield. The discretionary function exemption applies unless a source of federal law specifically prescribes a course of conduct. Right. So it's discretionary unless it's not. Wow. Right. So if you get to have a choice unless the law says you're prescribed, which is to say, do exactly this thing. And you know what a prescription is? A warrant. A warrant is a prescription, right? It's like, go to the pharmacy and get your meds, except go to this address and, seize the guns or whatever you're going to do. So you got a prescription. So, go do the thing. The exemption also applies irrespective of whether the government official abused the discretion. Okay, fair enough. Similarly to the discretionary function exemption, the Supremacy Clause ensures states do not impede or burn the execution of federal law. It sure does. It sure does. Separate sovereigns, states can't interfere with other states. The federal government can't interfere with the states under anti-commandeering doctrine. The states can't interfere with the federal government under Supremacy Clause doctrine. So the separate sovereign's going to separate sovereign, yo. So a state cannot make illegal what the federal government makes legal. under operative federal law. They can say that's not a thing the federal government can do. You don't have power. The Constitution doesn't allow you to do that. But assuming it does, they can't interfere with it, right? I mean, okay. The government may invoke the Supremacy Clause against state tort liability if it demonstrates the government officials acted have some nexus with furthering further policy and can be reasonably characterized as complying with the full range of federal law. Makes sense, right? If the federal official is operating under federal law, then, federal law. I mean, that makes sense. A government official acts bears some nexus furthering federal policy if they acted in scope of the discretionary authority. Okay. Similarly, a government official acts could be reasonably characterized as complying with the full range of federal law if its acts complied with a relevant constitutional standard, the Fourth Amendment. I mean, sure, if he complied with the Fourth Amendment, then, fine. That'd be cool. But then again, that's the very thing we're suing over, about whether or not that happened or not. Okay, when faced with the determination of whether actions a law enforcement officer took comply with the Fourth Amendment, courts employ objective reasonable test. In other words, we don't look to the subjective motivations of the officer. We just look at what happened objectively. And here, that's really easy, right? What were the FBI officers feeling inside? Did they hate the guy? Did they have malice? Were they trying to get him? Don't know. What I do know is they went to the wrong address, which is objective. So it's like, I don't need to know anything about what the FBI was feeling inside that day. I just know that they went to the wrong place. That's pretty objective. So, and consider whether the facts available to the officer at the moment of seizure or search makes a person of reasonable caution believe the action was taken appropriate. Yeah, not so much. They went to the wrong address. And then they write, this is, help me. We conclude that discretionary function exemption bars applicants' tort claims for trespass and interference with private property, negligent intentional infliction of emotional distress, and negligence. No. For every possible reason. No, it's not. Again, there's no discretion here. Just go to the address, read the warrant. Do this. Put the warrant up against your face and read the words. It says, you are hereby commanded to go to 123 fake place and in there search for evidence relating to drugs. And you can go look in the places for the drugs. And you can go look in the containers for the drugs. And also you can go into their garage and seize their car because we think it's the proceeds of drugs. Love, federal judge, XOXO. And then you're like, oh, okay. I know what to do. I do those things. I go do those things. I know what to do. The government has satisfied both elements of discretionary function exemption. With respect to the first prong, the record, viewed in the light most favorable to the suing party, evinces that they enjoy discretion in how to prepare for the warrant execution. Well, no. Not as it relates to trespass. Not as it relates to interference with private property. I'm not sure how you enjoy discretion in preparation for the warrant execution with respect to trespass, which is, I went to the wrong place. As we've previously explained, the FBI does not have stringent policies or practices in place that dictates how agents are to prepare. Well, maybe not how, but where? You're asking the wrong questions, court. You're asking the wrong questions. Furthermore, the preparatory actions Guerrero took before the warrant execution satisfy the second elements. Well, if I was suing you for somehow some of the things that you did in preparation, I guess maybe, but I'm not really suing you for preparation now, am I? I'm suing you very much for your execution. I don't know what you did to prepare, but clearly not enough. In Mesa versus United States, we explain the federal office's decision as to how to locate and identify the subject of an arrest warrant prior to service is susceptible to policy analysis. Well, I mean, fair enough, right? So how do the police go about locating and identifying the subject of an arrest warrant? I don't know. There's probably a lot of ways to go about doing that. And we got some choices about how we are looking for Jim. I've got an arrest warrant. This time I don't have a search warrant. I've got an arrest warrant. And the arrest warrant says, okay, I'm going to put it up to my face again and do this thing. It says, you are hereby commanded to find Jim Jones and return him to this court forthwith. Love, XOXO, federal judge. I know what I'm supposed to do. What am I supposed to do again? It says something about returning to the court. Okay, I need to bring something to the court. I need to bring something. What am I supposed to bring? Jim Jones. Oh, okay. I'm supposed to. So what you're saying is I need to find Jim Jones and I need to bring him into the court. Oh, okay. I understand the things. I get it. Now, how do I go about figuring out where Jim Jones is? And the court's like, I don't know. If I knew where he was, I would tell you. I don't know where he is. I need you to figure it out. That's what you do with your time. And so then they're going to go about doing whatever it is they do to figure out where the bad guy is. Presumably, they're going to go to his last known address, last known contacts, interview as many people as they can find, trace his credit cards, maybe his social media. Maybe they try to trace his phone, get a warrant for the phone. Who knows what they do? They can do many, many things to try to figure out where Jim Jones is. Sure. So they can do many things. Although it's unfortunate that despite his preparatory actions, they execute the warrant at the wrong house. See, again, you're confusing preparation with execution, right? He nevertheless failed squarely within discretionary function exemption. The Supremacy Clause, the Supremacy Clause, which says federal law is supreme to state law, bars the remaining FTCA claims for false imprisonment. How is the federal law inferior to itself? That's an interesting trick. The district court initially denied summary judgment on the false imprisonment and assault and battery grounds that discretionary function exemption could not defeat those claims because under the FTCA's private person standard, Georgia's citizens arrest statute does not contemplate good faith or reasonable defenses the government asserts. However, on government's motion for reconsideration, the district court granted summary judgment, finding our recent decision mandates dismissal. What the fuck? So Georgia, under its citizen arrest statute, does not contemplate good faith or reasonableness. You got to actually be right. Okay, but that's Georgia's call, and the federal government has said we're willing to hold ourselves to that. In a different case, we clarify the inquiry that determines if the Supremacy Clause bars state liability when federal officials have some nexus with furthering federal policies and can be reasonably characterized as complying with the full range of the Fourth Amendment. Well, that's all federal action, right? If state law, if federal actions cannot be liable under state law when they have a nexus with furthering federal policy, well, that's just anything the federal government does, hopefully. We don't dispute that there was a nexus with furthering federal policy when the FBI screwed up. We don't dispute that the FBI had a valid policy, go get the bad guy. We just say that you sucked really hard at it. You're just really, really bad at your jobs. You're just really, really bad at your jobs. But if the standard is it cannot be liability when you are acting further to federal policy, well, then the FTCA doesn't apply, because the FTCA only applies if the federal government is acting. It's the Federal Tort Claim Act, right? The Federal Tort Claim Act only applies in the first place if federal officials are acting pursuant to federal duty. That was the point. If they weren't acting pursuant to federal duty, then presumably they're just private persons, right? It's not an FBI agent. It's Stephen. Stephen might happen to be an FBI agent, but at this particular moment, he wasn't acting as an FBI agent because he wasn't doing the FBI thing. Stephen was just being Stephen in his everyday life, and Stephen is a dick. So you can't sue the federal government because Stephen wasn't acting in furtherance of being an FBI agent, which means also, incidentally, he has no protection because he wasn't acting pursuant to a federal agent. Well, you can't sue him under the FTCA. You can't sue him under the FTCA. You can sue him just generally because he's not a federal agent. But the entire point of the FTCA was to be able to sue them when they were in a nexus of furthering federal policy. And now you've just basically exempted out the entire FTCA. You've just undone an act of Congress. On the basis it violates the Supremacy Clause. I don't know. With respect to the first element, there's no doubt the official acted in the scope of his discretionary authority when he prepared for, maybe, and executed, much less so, the search warrant. Do you like that? Do you like that? How they just slipped that in? You like that, how they just slipped that in? Because in the previous paragraphs, they were talking about preparation. And in the final paragraph, they just slipped in executed. Like it's the same thing. They slipped it in. The analysis we must conduct to determine whether they comply with the full range of Fourth Amendment is the same inquiry we've employed in the qualified immunity analysis to determine whether the actions violate the Fourth Amendment. As we've already explained, they did not violate the Fourth Amendment. The government has satisfied both elements. Yeah, so we're in maximum stupid. We are in maximum stupid. And thus, we are left with the question presented to the Supreme Court, which this is the question presented in the cert in the case that was just granted cert. Petitioners are innocent victims of a wrong house raid conducted by the FBI in Atlanta, Georgia. Seeking remedy for the torts committed against them, they brought a cause of action against the United States under the Federal Tort Claims Act. Well, that sounds like a good idea, right? We're not happy with the federal government. Let's use a federal law that says the federal government can be sued and sue them. Cool. In its opinion below, the 11th Circuit held all the claims are barred by sovereign immunity, which the entire point of the FTCA was to waive sovereign immunity. That was the entire point. Supplied either through the Constitution's Supremacy Clause or the discretionary function exemption. In one or more ways, the opinion conflicts with the decision from every other circuit because it's really dumb. The questions therefore presented are whether the Constitution's Supremacy Clause under the FTCA, a federal statute enacted by Congress, when the negligent or wrongful acts of federal employees have some nexus with furthering federal policies that can be reasonably characterized as complying with the full range of federal law. Which at that point, like, what's left for the FTCA? What's left? And then whether the FTCA's discretionary function exempt bars claims arising from a wrong house raid and similar negligent or wrongful acts by federal employees. So Yeah. Yeah. So I thought that was particularly stupid. I thought that was particularly stupid. This is barred by the Supremacy Clause. The federal statute is barred by the Supremacy Clause. I'm not sure how, but somehow it is, I guess. So that was the decision by the 11th Circuit, and of course they found qualified immunity and everything else as you would expect, but still, that one is most maximum stupid. Where did they go to? How wrong were they? Let me read this real quick. Okay. So they were supposed to go to 3741 Landu Lane. And they were supposed to go to 3741 Landu Lane. They were supposed to go to 3741 Landu Lane, but they actually went to 3756 Denville Trace. Wrong street, man. Wrong street. That's just way too funny, man. That is way too funny. Yeah. Oh, yeah. That's way too funny. Lando? You think it's Lando? It might be Lando Lane. It might be Lando. All right, guys. Yeah, it's 500 feet away, which is, pretty significant. It's 500 feet away. So it's a football field and a half. Yeah, it's a bit of a hike. Oh Lord. Oh Lord. Yeah, it's football field and a half. Now, I don't know, incidentally, like whether or not they violated the Fourth Amendment. I don't know. So I'm not necessarily, and qualified immunity, as we unfortunately well know, is much, much more expansive than I think it should be. So I don't know whether or not the court is right as to any other part of this decision off the top of my head, but the idea that the Supremacy Clause bars the application of federal law, I think, is a new one. That's got to be a new one. I didn't know the Supremacy Clause barred the application of federal law. That's just all kinds of special. Well, my friends, I'm going to go ahead and sign off for now. But I would like to take a moment to thank who suggested this in my chat. Someone whose name begins with an S. Is it just literally S ... It literally is S ... Okay, in that case, I'd like to thank S ... on my Discord for suggesting this story. So I got this story from my Discord. And so I thought that was pretty good, and I appreciated the story. And so that is a friendly reminder that you too might be able to supply stories to me on Discord, particularly if they're really stupid and really dumb and they're don't make any sense. And we can make fun of the courts or whomever for the stupid. So if you have suggestions that you'd like to provide us, our Discord is a great place to go. I'd love to have you there. I've been Uncivil Law. Until later, my friends, I really hope all is well. Cheers, my friends, for now, and goodbye.